Next case on the docket is Michelle Lynn Desjardins versus State.
Thank you.
Thank you.
Thank you, Your Honor.
All right.
Good morning. May it please the court, Attorney Brian Savy on behalf of Appellant Michelle Lynn Desjardins. I have three issues that I've raised in my initial brief that I want to address today with this honorable court. First off, appellant was convicted of DUI manslaughter in the trial court out of Brevard County. Of course, one of the elements of DUI manslaughter the state must prove, of course, is that the appellant was in actual physical control of a vehicle. The first issue that we're raising is the state failed to present competent evidence the defendant was in actual, or appellant, excuse me, was in actual physical control of the vehicle.
Is it your position that your client was not driving the vehicle?
It is my position that they did not prove by competent, substantial evidence in their case in chief that my client was driving the
Is there
vehicle.
any evidence that anybody else was driving the vehicle?
There was no other evidence presented that anybody else was driving the vehicle. That is one of the distinctions between the cases that I believe the appellee raised in their answer brief. That is the only distinction, I believe, between these two cases.
I guess what confused me, and maybe you could help me with it, Mr. Burkhart was an eyewitness to the accident.
Correct.
Said he saw the car, saw a blonde-haired woman driving. Did he not testify at trial that the defendant is the one I saw driving?
He did not.
So what your argument is that his testimony had to be coupled with the police officer's testimony, who I assume testified that was the person I talked to at the scene? Who identified the victim or the defendant in court?
Police officer.
Only the police officer, correct. The law enforcement officer, Corporal Charles Jones, the Florida Highway Patrol.
Mr. Burkhart said he told the police officer who it was, correct?
Mr. Burkhart stated, and these were his words, and this is, well, actually, it was actually the state attorney's words, did you see the occupant or one occupant of the vehicle? He indicated that he did, and he identified that occupant to the law enforcement officer. He never stated
Any
that
dispute that was the defendant?
I'm sorry?
Any dispute that that was the defendant?
There was no dispute at the time that
So is the key that he said occupant rather than driver?
I believe that is a key distinction. And the reason it's a key distinction is because if he says driver, that makes it the perpetrator. He's making an identification of the perpetrator.
There's nobody else on the scene or in the car, isn't that at least circumstantial evidence from which a jury could conclude that she was the occupant and therefore the driver because there was only one person in the car?
I believe that maybe the sole circumstantial evidence that they can even point to is the absence of another identification of a driver.
Why is that not enough to overcome a JOA?
I believe it is enough to overcome a JOA. I believe the fact that...
Then why are we arguing? Why have you raised the issue then? If you said that
I misstated my position.
Go ahead.
I do not believe that is enough to overcome a JOA argument at the time. Merely the absence of identification of another person is not going to remedy the lack of sufficient evidence that it was this particular person. Essentially, the defendant does not have to prove anything, and the fact that merely there was not someone else identified as a driver should not be held, and it's almost as if this...
But the circumstantial evidence I think Judge Palmer was referring to is the absence of anybody else fitting the description of the person Mr. Burkhart identified as a witness as being the driver at the scene.
And I understand what the court is saying in that regard. However, that is the only distinction is that there was not someone else identified. And when in the criminal trials, there's going to be someone else identified. Very rarely is someone else going to be identified as the culprit or a perpetrator. That's a moment you see on TV. That's not something that's going to happen very commonly, and that's the only distinction. If you look at the other cases that this court has heard, Montanez v. State and Syverud, there's copious amounts of circumstantial evidence in those particular cases. In regards to this particular case, it doesn't even compare.
Well, the officer said, Mr. Burkhart told me it was her, correct?
He did.
That's what he said, right?
He did say that, and an objection was made to the hearsay
About
nature.
hearsay.
Correct.
Which is overruled.
It was overruled, I believe, improperly, because what the issue is Corporal Jones can only get that into evidence. That prior identification is if another person testified that an identification was made of the perpetrator.
Right.
And that's the
Well,
key
that's what
distinction.
led him to then talk to her and to arrest her, is that right?
He said, I believe it was very generalized, he said that his investigation led him to the identification of Ms. Desjardins, the appellant, as the driver. I believe that's what his testimony was, and is also objected to as hearsay as well at the time, contemporaneously. So, essentially...
Well, was it potentially introduced for other purposes such that it wasn't hearsay? As part of the description of how he undertook his investigation, what he did, those sort of things? In which case, it would not be hearsay, correct?
It's hearsay, the identification of Ms. Desjardins is hearsay. The fact that he somehow got somewhere to arrive to talk to her, I don't believe is hearsay, correct. However, the identification is what the issue is here. Whether an identification was made to Corporal Jones, whether that person who made the identification testified.
If they'd asked the officer, why did you talk to the defendant, and he said, because the witness told me she was the one driving the car. That would come into evidence, right?
No, I don't believe it would be. That would be related to...
It wasn't to prove that she was driving the car, it was to prove why he conducted the investigation and chose to talk to her, right?
Yeah.
I agree with that point, yes, that would. However, he's not an eyewitness to, merely because someone else told him that this person was the driver. If that person didn't make the identification in court, if that person didn't testify about making this identification of Ms. Desjardins as the driver, that's where it's problematic though, because it wasn't ripe for cross-examination. If Mr. Burkhart doesn't make the identification in court and says, yes, I identified the driver or the...
Now let me ask you, I'm a little confused on one fact.
Sure.
Did the eyewitness say the defendant was the occupant and your issue is occupant during driver, or did the eyewitness simply say, I told the police who the occupant was, but didn't say on the stand, and I told him it was the defendant?
What I believe the record reflects is Mr. Burkhart testified that he observed one occupant, and he identified that person to Corporal Jones.
But he didn't identify that person as the defendant?
Correct.
Okay.
That is correct. Essentially, I'll rely on the rest of my reply or initial brief on that argument. I'd like to move on to my second issue, whether basically our argument is Corporal Jones properly advised appellant of Miranda. Appellant unequivocally invoked Miranda. Corporal Jones did not scrupulously honor that invocation, and the state used those statements.
Did the trial court found that it was not a custodial inquiry? That she wasn't in custody?
The trial court did find that.
Factually.
Correct. The trial court did find that. I don't believe that's the end-all, be-all, and the case I want to reference, because I really couldn't find too much on this, is some language out of actually the First District Court of Appeal in Riley v. State.
We never listen to them, they don't know what
Yeah, they're pretty far north, you know what I mean?
I understand. Whether violation of defendant's constitutional rights has occurred should be reviewed on a case-by-case basis according to the language. A lack of custodial interrogation should be but one factor that the court looks at. In the case at bar, the defendant was at the very least detained.
Well, yeah, okay, go ahead.
At the very least detained and properly advised of Miranda pursuant to the accident report privilege. She invoked, and her invocation was not honored. A constitutional rights violation occurred. Because
So if it's not a custodial inquiry, the officer does give the person the Miranda warnings. They say, I don't want to talk to you. So that's the end. Then he's done. Is that right? Even though they're not in custody.
He can't question her. He can't continue to question her unless she wants to reinitiate the discussion.
That usually goes to when you're in custody, doesn't it not? If you're not in custody, what difference does it make?
It does make a difference. I believe it should be reviewed on a case-by-case basis.
Okay.
It would be illusory to read someone their Miranda rights and when they don't really have them. If we're not going to honor an invocation, what's the point of reading them the Miranda rights?
So by the officer giving someone Miranda that's not in custody, he's invoked it. In other words, they got a right not to say anything, and if they do say something, is tossed.
If they're required by law to, and they're required by law to pursuant to the accident report privilege. And I know there's some situations where officers will just advise a Miranda, they may not have needed to, and that might be on a case-by-case basis, but in this instance, he was required to, and he properly did advise her Miranda. He's a seasoned...
And he asked her, would she talk to him? And she said no.
Correct.
And he asked her to speak up, and she said,
I'm scared.
no, I'm scared. And then and he asked, you're scared, and then at that point, she became
Kind of a whip.
she talked quite a bit. What was the interrogation, what was the violation of Miranda that he committed? At what point did he cross the line and interrogate her when she'd invoked her rights?
Well, I believe Your Honor is correct. She did make some other statements, but what the court needs to focus on is that she did not reinitiate questioning. And the other point is that anytime after she invokes, if she begins to talk again, they need to readdress this invocation in her invocation of her Miranda rights. They need to readdress that, and that was not readdressed. Subsequently,
so when she said, no, I'm scared, instead of the natural human reaction of, you're scared, he should have said, I don't care if you're scared, you've invoked your right, stop talking. How should the officer have handled it? Well, I mean, I guess what I'm troubled with is, I understand your argument. He read her Miranda whether he had to or not, maybe he's irrelevant at this point. He did, she invoked her rights, and then usually the cases involve situations where despite that, the interrogation continues, and I'm just having trouble seeing that here.
it did continue. It didn't continue right then and there, because
That's the point where she right then and there is when she began making very incriminating statements.
Well, I don't believe she made incriminating statements. According to the record, I think what she said...
It's irrelevant if there was a Miranda violation, right?
I'm sorry?
If she didn't make any incriminating statements, isn't it irrelevant whether Miranda was violated?
Well, she did eventually make incriminating statements, and I was referencing what she initially said after she said that she was scared, or after she was asked.
Well, the incriminating statement, at least for purposes of your JOA argument, is she was driving.
And I understand that. However, the incriminating statements that they admitted in the state's argument, and this is what the argument that they were making, is that she admitted to consuming unwittingly alcohol by her very response to the direct questioning and its functional equivalent of the questioning that was regarding the odor of alcohol, the consumption of alcohol, and the possession of alcohol. At that point in time, the state implored the jury in opening statement and in closing argument to focus on that admission.
If you don't win on your Miranda argument, you don't win on your JOA argument, right? Because there was testimony from her that would
Correct.
establish she was the driver, right? So you got to win on the Miranda argument to win on the JOA argument.
I guess the court could put it that way. If I may move on to my final issue that's raised in the initial brief. This is more dealing with the way the state presented its case. There was two specific things that I've raised that were both objected to at the trial court level. During voir dire, the trial court read a list of potential witnesses to the venire, including George Foster, the stepfather of the decedent, in this case, Daniel Smith. Upon reading that, the panel answered in the negative that they did not know this individual. The state then proceeded to introduce to the jury the same person, Mr. Foster as the stepfather and Bessie Smith as the mother of the victim. The state did so under the guise of wanting to make sure that they didn't know him. Well, they already knew that. The state already knew that.
How did they know that?
Because they had already answered in the negative.
Isn't it possible that somebody might recognize somebody if they saw them, but they didn't recognize them simply when their name was given?
Well, I agree. And Mr. Foster was in court at the time and sitting there watching the venire. That's why he was able to be introduced. So at the time they're reading Mr. Foster's name, not only one, first off, he was visible to the jury because he was sitting in open court. Two, his name was already read to the panel and they stated they didn't know him. And three, he was in open court, clearly visible to the venire when his name was read, and the whole panel still said they didn't know him.
Well, but how do those two relate? When they gave the name, they didn't say, this is him, right?
Not at the time, no.
Okay, so a juror could have seen him in the audience, say, I know that guy, but when they say, do you know George Jones, they could say no because they didn't know his name, and this is one way to assure that they don't know this guy, right?
Well, if they knew that guy, they would know him as George Foster.
Maybe.
They might, or they might only know him because he's they see him every day walking down the street and they don't know his name.
I mean, that's a fair point. However, at the time
I've had that happen as a trial judge, where, the next day that a juror says, well, that's my, I'm related to that person. I mean, I don't know why they didn't know it at the time.
And I understand the court's position. I'd like to move on. I don't have much time left to move on to my, the final part of that argument. The state admitted a postmortem photograph that was not relevant to prove a material fact in dispute. They offered a postmortem photograph of Daniel Smith into evidence. We objected on numerous grounds. We offered to stipulate to the cause of death and the identity of the decedent. The state's response seems to accept our stipulation as related to the identity of the decedent, and based on the state's questions of the ME, the only proffered reason would be to establish cause of death. The photo did not depict cause of death, it did not depict any injuries, maybe a minor laceration, but it did not depict the cause of death, which was lacerated aorta and blood out in the chest cavity, liver, and spinal rupture, lacerations, and loss of blood. And I believe I'm relying on the Connor v. State case, and basically that was, the sole purpose was to elicit sympathy, and that was improper. It was not relevant to admit that photograph.
Thank you, counsel. Your time's expired.
Thank you.
May it please the court, my name is Pam Kohler, representing the state of Florida in this appeal. As far as the state's concerned, obviously we established that she was the operator of the vehicle. I think the reason the state hadn't gone farther is because nobody ever disputed that she was not the driver. I mean, even during her statement to the trooper, she's saying something about, oh, the keys are in the ignition. Oh, the keys are in the ignition.
Why would the prosecutor ask Mr. Burkhardt, is that the person? I mean, come on.
Yeah, I don't know. I don't know why he didn't go that one step.
Not in a convoluted way, that's for sure.
It sure is, but I mean, we do have Mr. Burkhardt being asked, she was the only person in the vehicle, identified her to the trooper.
He obviously saw her.
Correct.
Yeah, I mean, he could have identified her.
I mean, he didn't know her name, when they played his statement to the police, he basically said, yeah, she's the lady with the blonde hair and the white shirt, so, I mean, he clearly knew who she was, at least that night. And sometimes witnesses can't identify somebody the day of trial, especially when it's a couple of years later or whatever it is, but,
well, they didn't ask him.
They did not ask him.
Right.
Right. And he was the only one, because when it sounds like, there are other witnesses who said it was clearly a woman who had been driving, but they could not identify the defendant as that woman who had been driving, so.
And the defendant admitted she was
She did.
driving, right?
Both in her statement and under oath during the trial, yes. She admitted she was driving. She admitted that she saw the vehicles and, some headlights coming towards her, and that she had drank the vodka after the accident, so, and that she had lied to the police about that, so.
Of course, other than the statement that relates to the Miranda issue, none of that came in until after the JOA, right?
Correct. Correct. And as far as the Miranda, she wasn't in custody. He clearly wasn't interrogating her. He's trying to get through Miranda. He asked her, he doesn't hear her the first time. She says no. He asked her to speak up. She says, I'm scared. And, he essentially cuts her off. And then later she says, I'm not going to say anything until I want to talk to my dad or my lawyer. She asks, can I get out of the car and talk to my dad? Sure, get out. She's over there talking to her dad. He comes up, basically, I think, it's my understanding that he's trying to explain to her, this is why I want to ask you to do the FSTs, that I smelled an alcohol on your breath, and that's when she responds, not that strong, so, he's trying to get through what he has to do to conduct his investigation. That's all he's doing. He's not interrogating her about what happened, so.
If Miranda wasn't required because she wasn't in custody, yet Miranda was given, what's the effect of that?
Well, Miranda is required in that case, according to the Florida Supreme Court, because the whole point is to tell someone you're no longer required to answer the questions.
It has to do with the accident.
Correct.
Right, okay.
And in this case.
I guess you misunderstand my question.
Yeah.
If I understood your argument correctly, in the trial judge's findings was she wasn't in custody,
Correct.
so Miranda really wasn't necessary.
Well, I think it was only because the officer was investigating an accident.
Correct.
And then changed to a criminal investigation.
Right.
And I think it requires him to say that.
It does, under Florida case law,
fact, it's
in
just
order to
unusual.
advise them, because the whole point is, before they start answering questions in the criminal investigations, they have to understand they don't have to answer questions.
Right.
And so what the Florida Supreme Court has said, you have to tell them it's a criminal investigation and advise them of their Miranda rights, so they
So
understand.
Miranda was given under the statute, not
Correct.
because she was in custody.
Correct.
Okay.
It's because the Florida Supreme Court requires it. So they cannot invoke the accident report privilege at that point. And in fact, in this case, we not only had the change of the hats, we had change of the troopers. I mean, the one trooper on the scene was the one investigating the accident, and then Trooper Jones came in to investigate the DUI manslaughter. So that was the
So none of
difference.
this stuff about being in the car and going talking to her dad is really relevant to anything here, is it?
Other than to show that she didn't feel like she had to answer questions. I mean, she clearly wasn't under any kind of coercion, or she felt like she had to, stick around and answer questions that the officer was asking her. I think it goes to that.
Well, he was going to, conducting his investigation, he was going to continue to conduct his investigation, and, I guess could compel her to respond. The result of that would be that those statements would not come into evidence.
Yeah, he couldn't compel her to respond to, he can ask her the general information he needs to know.
I guess
her
my
name,
point
date of birth.
is, I guess where I'm maybe seeing the distinction here is that, in a true Miranda custodial context, once she invokes, he can't keep investigating, can't keep interrogating under the statute, under the criminal investigatory statute. He can continue to ask her until the cows come home. Any statements that she makes would be under the accident reporting privilege, right?
I don't think he can, if she invoked her Miranda rights at that point, he can conduct his investigation to the extent that he can do the FSTs, because those are non-testimonial, so you're not getting someone to violate their Miranda rights. He can ask her for a blood draw, because basically he can force it out of her at that point, because there's a death and alcohol involved. So nothing that the officer had to do after that really would go to Miranda per se. Now, if she says, no, I'm not going to talk to you, I'm invoking my Miranda rights, and then he kept asking her questions, I think there could be a problem, because at that point, she's being told she does have a right to remain silent.
Right, but it's not a Fourth Amendment, Fifth Amendment issue. It's a statutory accident reporting privilege issue, isn't it?
The whole point is to basically say that, right, that, they can't invoke accident report privilege if they get it court, so it can be used against them.
I think what Judge Weatherall is saying, if I got this right, after he changes to a criminal investigation, you give the person the Miranda warning.
Right,
They're not in custody.
correct.
You continue to ask questions to them as part of your investigation. And if they say, first of all, when he gives them Miranda, I don't want to talk to you.
Right.
All right, so they invoke it. But he continues, none of those statements are admissible, correct?
Right, yeah, because
Even though you're not in custody.
right, because the whole point is they need to know that they don't have to answer these questions. So if they feel like they still have to answer the questions, then you cannot admit them against them.
That's right, okay.
I don't know if this court has any further questions. I'll rely on my brief and ask this court to affirm.
Thank you, counsel.
Thank you.
Thank you.